I'll simply say status quo to be maintained.
Now exactly what
Cool. I've just said status quo to be maintained. What has he done? Where is the order?
kindly consider my one other proposition is wrong. Just one other proposition.
Is this an interim order or final order? Interim order is asking.
One proposition you may consider from my
Kiran, by way of interim order can he?
indulgence. That's one indulgence. Now the petitioners have approached this honorable court. They are relying upon the special DC order. Now, in a collateral proceedings, now I as the respondent can say this special DC order is a nullity in law, and I am relying upon the KT order to say that. Even in a collateral proceedings, I can say law permits me.
What is the revenue entries do now? What
Lordship may kindly
in whose name do the revenue entries stand now?
in the name of the petitioner,
On the basis of?
on the basis of the special DC order, which is a nullity.
So by way of interim order, could not have restored it. He's virtually allowing the revision then.
As on date, you don't
It's like me quashing an.
one submission. As on date, the lands belong to the state government. Now they.
That's why I suggested I'll maintain.
It's not the moment their name is entered in the, they will continue to
No,
transact.
you be correct on facts. Is their name already entered or to be entered?
They want to receive instructions.
Status quo antane ನೀವು.
I'll find the statement.
And if by the time if he's going to continue the, I get the feeling that he will allow the revision. Because, Madam, for the first time I am seeing an interim order of this nature, whereby the revenue entries are restored by virtue of an interim order. It's like me quashing the impugned order, subject to my final order. Can I do that in the writ petition? Can I quash an annexure subject to the final result of the writ petition? That's exactly.
To that extent, your lordship is right. By way of an interim order, the status anti could not be. It should have been the final order.
Shall I stay this order until then?
Lordship may kindly have it, yeah. Otherwise, it is like rewarding them as against the suppression.
I don't want to do
That's
that.
all.
I don't want to do that, but I can't entertain this regional
I'll
commissioners.
come back to it. I will instruct the regional commissioner not to pass any orders. Lordship may kindly have it, yeah. But today they have.
Shall I record your statement that
Lordship may kindly record.
when the AG submits that the regional commissioner will not proceed the matter further? That will matter. Relist on. When do you want it?
Lordship may also record that the KT order that they have suppressed.
I am only saying that
Part of the order.
when the AG also submits that there is an order of the Karnataka Appellate Tribunal whereby the Karnataka Appellate Tribunal has rejected the prayer of the petitioners to issue a Sagwadi check.
They may be called upon by this fact to suppress, because if they have suppressed, then petition is liable to be dismissed.
I'm not going to, that's why I said I will not touch on the merits of the case. You have not challenged the order of the DC.
No, I will not, that's my submission. Because law says, whenever they are relying upon, I can say that collateral.
Kiran, if I were to hold that the regional commissioner had no jurisdiction, what is the consequence?
I'll come back on it. Lordship has raised their doubt, I'll satisfy them.
When do you want it?
Lord, may I request on Thursday?
Thursday. Thursday.
24th, no, 23rd, then your lordship may have it.
No, right. 60, 61, 62, 63. That's why I said I'll grant status quo. You said
I requested that I will instruct the regional commissioner now itself.
then I'll simply say status quo to be maintained till. I didn't want to put you under pressure. Therefore, I said I'll say status quo till then. You wanted. I cannot sit quietly when such an order is passed.
That's why I request 23rd your lordship may.
Status quo to be maintained till then. It's your choice, or else I'll stay this order. There can't be such. There can't be an interim order in these terms. Madam, then nothing's going to happen if I grant a stay.
Anyway, as the next date of hearing is on 17th.
No, I simply cannot,
Pass orders before 17th.
Kiran, I simply can't accept such kind of an interim order.
I'll come back if you have to put query on.
Status quo.
No proceedings are in fact taking place next week before the.
You are the author of this mischief by going to the regional commissioner.
My lord,
If you had filed a,
mischief is done
if
by
you had
the
filed a
court.
writ, if you had filed a writ petition,
My lord, the
if
mischief
you had filed a
is
writ
done by
petition,
disclosing.
if you had filed a writ petition, matter would have been different.
My lord, ultimately, the special DC has passed an order by them not disclosing.
As
the
it is,
fact.
madam, they are playing havoc with the system. Now the highest authority starts stepping in at 136(3) proceedings.
Our only submission, my lord, next week, my lord, the beginning.
Status quo to be maintained.
My lord, may not at least fix the status quo order. It amounts to a say then on the media. Let us clarify.
I am inclined to quash the order right now. Because he said he'll get instructions regarding 136(3), I am keeping quiet.
Then, my lord, the matter is only day after.
Good.
And,
Number 65.
then no further
Ramesh
orders
Kumar.
will pass.
65. ಏನ್ ರೆಡಿ ಅವ್ರೆ? ರೆಡಿನೇ ಇಲ್ವಾ? List. Interim order to continue to the next date. Where?
Seal number 68, H.N. Baswaraju. Seal number 68.
Some names which are restricted, they are not included in the two part of subject issue. We have a set, the entire land is the subject.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀರಾ? A3. Like you're challenging what notice issued? AA1 is a notice.
AA1 is the notice is part of section 51
ಏನ್ ಮಾಡಿದ್ರಿ A3 ಅಲ್ಲಿ?
Land was transferred to the blanket in 1994. The report submitted by the Tahsildar was treated as a common to appeal. And it is the appeal provision is invoked to transfer the land. On the ground that mud NTC 1994 to Sarkari Dase, it should not have been granted. It is granted.
94 grant na?
94.
In Manjunath? Cancelled when?
Only 2025.
AJ accepts notice correspondence. ನೀವು ಅಷ್ಟೇ ಅಲ್ವ ಇರೋದು? ಆಫೀಸ್ ನೀವೇನು ಸಬ್ಮಿಷನ್ ಇದೆ ಏನಾರು?
Submission and the all the land.
No. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿದೆ?
ಅದೇ ಎಲ್ಲ ಲ್ಯಾಂಡ್ ಕಾರ್ಡ್ ಆ ಇಂಟು ಲ್ಯಾಂಡ್ ಒಳಗೆ ಪರ್ಟಿಕ್ಯುಲರ್ ನೇಮ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. Machines are limited in the land. Some of them are trusted, some of them are land. But the annexed
Parties name differ with. Like, if you want an interim order, what is the inter? If suppose a grant in.
not first we have the AC order.
ಅಲ್ಲ AC order ಹೆಸರು ನಿಮ್ಮ ಹೆಸರು ಇಲ್ಲ ಪಿಟಿಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ
They are not purchasers, amendment proceedings get ಮಾಡಿದ್ದಾರೆ. Land is where ಮಾಡಿದ್ದಾರೆ. Our land is included.
ನಮ್ಮ ಆಫೀಸ್ ಮತ್ತೆ Learned Senior Counsel submits that the difference in the names found in the cost title and the names found in the order of the District Commissioner is because some of the petitions are purchasers from the grantees and hence their name is not found in the cost title. This submission is accepted. This submission is accepted. AG accepts notice for respondents. There shall be an interim stay of all further proceedings pursuant to Annexure A3. Objections, if any, in 3 weeks. And to be permitted.
For hearing on IA, seal number 72. AC Manjunatha.
Notice ಹೋಗಿದ್ಯಾ? Issue notice on IA 1, 2 and 3 of 24.
Seal number 73, Shri Anjaneya.
Even the petition has been indicated to the land matters on the ground that the land spots within the radius of the kilometers. The application has produced the notification also. Now, they say that even after application of the 1999.
ನಿಮ್ಮ ಮೇಲೆ ಇದು ಮಾಡಿದ್ದಾರೆ 25/3/25. AJ is directed to make a statement as to the extent of the amount of lands that were granted in number 49 after 12/10/1995 and also state on what basis the orders were passed. And if the orders were based on regulation of unauthorized occupation, she shall also state the date on which the applications of the applicants herein were made. So,
Seal number 74, Shri Chittappa.
notice ಹೋಗಿಲ್ಲ ಅಲ್ಲ? She notice on IA 1, 2 and 3 of 25. Notice.
Seal number 75, Shri Ganapati Bhatt.
ಅಲ್ಲ ಇಂಪ್ರಿಂಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಯಾರು ಹಾಕಿರೋದು? Like the first matter ಅಲ್ಲಿ IA 1 for impleading applicants as additional respondents. ನಿಮ್ಮನ್ನ ನವೀದ್ ಅಹಮದ್ ಯಾರು ಹಾಕಿರೋದು? ಅಲೋ ಮಾಡ್ಲೇ ಬೇಡ ಅಪ್ಲಿಕೇಶನ್ ಅಪ್ಲಿಕೇಶನ್.
Seal number 76, Government Advocate.
Finding of the KAT is that the government has enforced our the order passed. We filed a mandamus for the implementation of that order. Now at this stage, they are coming up with the construction of
IA 1, this is the R1 file. Log it. You made an application for? Where is the application filed by you? ಯಾವಾಗ ಹಾಕಿದ್ರೆ? It's not put up. Stated that an application for TI is made. Office to verify and put up the same. You have to do.
Seal number 77, Shri Akshay Kumar Jain. Seal number 78, Shri Saravana S. Saravana S.
Application.
Number 79, Shri Mahesh Kiran Shetty.
After vacation.
Seal number 80, Shri Manjunath Prasad.
In the petition of check persons have been approved to be spoke watching. The expeditions filed by the other expedition states to be liberty watching. They were
Not counsel, the petitioner submits that the issues raised in this writ petition are covered by the decision entered by this court on 8th of November 2024 in WP 20220/2024, whereby this court dismissed similar writ petitions, reserving liberty to the petitioners to approach the appropriate authority as against the impugned orders therein within a period of 1 month. So he submits that this writ petition may also be disposed of in the same terms. In light of the above, this writ petition is also disposed of in the same terms as in WP 20220/2024.
Number 81, Shimali Patil, PS.
Who's for the petitioner?
Yes, Shimali Patil.
Mali Patil,
Serial number 81.
left after vacation.
Hey, I appear for the,
Yes.
huh? I appear for the respondent in 81, serial number 81.
Or petitioner ಇಲ್ಲಿ after vacation ಹಾಕೊಳ್ಳ.
ಅಲ್ಲ ಅದರಲ್ಲಿ there is some urgency, ಅವ್ರು ಬರೋದೇ ಇಲ್ಲ. We have moved for vacating the interim order. A meddlesome interloper, a busybody, without any locus, makes a writ petition in the name of the temple. And gets the interim order, gets an interim order suppressing our rights. I am a purchaser from a person who has been registered as an occupant under the religious and charitable,
I'll have it day after tomorrow. If it does not come, I'll take it up.
ಆಗ್ಬೋದು.
There's no appearance on
Great.
behalf of the petitioner. As a last chance, relist on.
23rd. Number 82, Shiva B. Raya.
Copies of the IAB furnished, relist. To the petitioner's counsel. Could you not copy code?
Serial number 83, Shri Radhanandan, PS.
Case on date code. 83. Ready na? Ready after vacation. Interim order to continue. ಆಗಲ್ಲ ಕಣ್ರಿ. ನೀರು after vacation. Interim order to continue.
Serial number 84, Shri Shivaram Bhatwa.
In clarification. Application election. Against this order, it is stated that review is preferred. And why will you require this application? Review has been preferred against the order passed on 4th of February 2025 in this writ petition. In RP number, post soon. Serve a copy on him. Jyotili. ಯಾರು ಇರ್ಲಿಲ್ಲ ಕರೆದಾಗ. After tomorrow.
For further consideration, serial number 85, Shri Arjun Rao.
My lords, I beg to appear for the petitioner. My sincere apologies, my lord. I'm not there physically. Kindly permit me to make one submission, my lord. My lord, this is that panchayat tax matter. On 24th of March, they had given a calculation. We accepted that calculation, my lord, without prejudice and agreed to pay. We gave a demand draft also. After that, my lord, the panchayat said that there was a sum of around 9 lakhs due. Your lordships directed us to submit the proof and reconcile. Out of that 9 lakhs, my lord, now they have said that, and they have given us a copy of a document, 4.5 lakhs they have adjusted. Another 4,40,000, my lord, they say that we have given the DD, but the bank statement should be produced by us. My humble submission would be, my lord, we'll write to the banks and we'll get those statements. My humble request is, your lordships may kindly dispose of this, my lord, since with regard to the amount due, there is no dispute as such. And your lordship may kindly fix a time, my lord, we'll make good whatever shortfall is there, my lord, if we are not able to satisfy them. Filed a detailed affidavit, my lord, along with their calculation, our acceptance, etc., my lord, on 2nd of April.
After the matter was heard in length, it was pointed out that the panchayat could make a claim only as per Schedule 4, no?
Please, my lord.
Schedule 4, and could not have made a claim on the basis of model bylaws in respect of the lands which belong to the petitioners on which the hoardings were erected. It was also pointed out that the claims in respect of the lands which are covered in agreement would be covered, would have to be decided in accordance with the agreement and not in accordance with Schedule 4. So after the arguments were, the panchayat finally filed a statement of accounts stating that a total sum of rupees 84 lakhs 68,662 was due, and the petitioner had paid only a sum of rupees 64 lakhs 77,840, leaving a balance of rupees 19 lakh 90,858. Next, on 8/4/2025, the petitioner submitted that the panchayat had not taken into consideration the sum of rupees 10 lakh 82,000, some that was paid by the petitioner, and according to the petitioner, only a sum of rupees 10 lakh 82,938 was outstanding, and a demand draft was also handed over to the panchayat in this was said amount. Learned Council had also pointed out that they would approach the panchayat and bring to their notice the monies that had been paid by the petitioner but had not been accounted for in the demand of the panchayat. So today a submission is made that out of the balance of 9 lakhs,
9,07,920, my lord, the balance, panchayat has reconciled and accepted payment of 4,64,880.
4,62,000.
4,64,880 they have accepted, my lord, and according to them, now the balance is 4,43,040.
And so the remaining amount of is 4,46,000.
My lord, remaining amount according to them is 4,43,040.
40. So the panchayat is insisting that the bank statements are required to be produced by the petitioner. So in the light of the fact that the petitioner has paid all the demands and there is only a dispute in relation to the sum of rupees 4 lakhs so and so, it might be appropriate to dispose of this petition by directing the petitioner to produce the bank statements for payment of the said sums, sum of rupees 4 lakhs so and so. And the panchayat, if satisfied that the money has been paid, obviously the demands that are due to it would stand complied with. If however the bank statements are not produced, the petitioner shall pay the aforesaid sum of rupees so and so. In the light of the above, the writ petition would not survive for consideration, same is accordingly disposed of.
I'm so grateful, my lord.
Number 86, Shri Mohammed Tai.
Inayat, madam.
We have filed affidavits of all the departments, principal secretary. ಎಲ್ಲ upload ಮಾಡಿದ್ರೆ some acts pertaining to revenue rules which are yet to be established and yet to be. Most of them are filed there. The hyperlink is provided, it's been uploaded.
But in the website, it only says amended rules 21, 22. The entire original rules is not at all available.
But we are working on that.
How many departments have filed the affidavit?
All the departments. 2021, which
Yeah,
they are in
proceed.
charge of different departments. My lord, may kindly take it up day after day. I filed a common compilation of the data from the DPA parliament.
Day after tomorrow, 25th.
My way is getting stuck because of this.
ಆಯ್ತು. All-
Promotional validity we need to ask.
25th ನೋಡೋಣ ಬನ್ನಿ, 25th.
Larger issues.
No larger issue, my submission is that the particular rules are not applicable in my. I have to demonstrate this.
25th ಮುಗಿಸ್ತೀನಿ ಬನ್ನಿ.
Number 87, Shri Vikyat.
The petitioner in this case, my lord.
ಅವ್ರದ್ದು ನಿಮ್ದಲ್ಲ, ಅವ್ರದ್ದು ಇರೋದು ಅಷ್ಟೇ. ನೋಡಿ 25th ನೋಡೋಣ.
Number 87,
The petitioner in this case, my lord.
ಏನಾಯ್ತು?
Lord, I filed my affidavit, my lord. They have to consider it, my lord.
Particular area, if they leave yours 30 feet road, it will be up to here. Whereas this particular area, yours, once again, there is a site which belongs to their family.
ಏನಾಯ್ತು?
They are not willing to do that.
My lord, I filed my affidavit, my lord.
ಏನ್ ಹಾಕಿದ್ರ?
My lord, so that the road and conservancy to be shifted together in the middle of the affidavit. The recent affidavit which was filed, in which I've also shared the plan where the road and conservancy to be shifted together. We're living around 6 sites, my lord.
ಏನ್ ಮಾಡ್ಬೇಕೀಗ?
The 6 sites matrane I'm requesting for a plan approval, my lord, for the building construction.
Then I'll release it from parted.
Please.
Release from parted.
Seal number 88, Shri V. Balakrishna. Shri V. Balakrishna.
So there was a confusion about the names.
Who appears for BBMP?
I clarified this document clarifies those names.
Where is the BBMP council? Pass out.
Can I speak?
Audio. Pass out.
For further hearing, seal number 89, Shri Veer Bhadraswamy.
What happened? ಬಂದಿತ್ತು ಏನೋ ಬಂದಿದ್ಯಾ? ಕಳಿಸಿದ.
Thereafter, the sale date was.
What happened there afterwards?
Police registered and started making inquiry. And they tried to.
That was on,
Report on the last day.
that was on 18/3. What happened in the matter is for a period of 4 weeks to enable the SI to conduct the investigation. ಇಲ್ಲ ಅದು ಮಾಡ್ತಾ ಇದೀವಿ, ಟೈಮ್ ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು. 4 weeks ಕೊಟ್ಟಿದ್ದೆ, ಆಮೇಲೆ ನನಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. Day after tomorrow.
Seal number 90 adjourned. Final hearing matter, seal number 91, 23rd. Seal number 91, Shri Saravana S.
Notification.
For hearing the group, seal number 92, Sri G. Lakshmi Straw.
ಏನ್ ಮಾಡಿದ್ರಿ? Page? ಯಾವ ರೂಲ್ ಹೇಳಿ? Yes. ನಿಮಗೆ ಅದ್ರ ಮೇಲೆ ಕೊಟ್ಟಿದ್ದೆ. Let us see the order. Granting it to you. I thought it was regularization. Where is the order in your favor? Let us see whether it is under Rule 14(4)(2). Show me under the order it was under 4(2). 70. Where is the original order, Lakshmish? The original order of grant. Original order idea. 77/2000.
This is the original order during which he was confirmed 10 root as a match.
No, this is the order passing on appeal.
This is the appeal only was granted.
No, where is this?
Connection D. This trial was rejected.
No. I want to know under which under which provision he sought for grant. I thought you told me that it was because it was unauthorized occupation.
This is contention. My contention that I will dismiss person.
Imdalla, he is now changing his stand. He is saying that he was granted the land for better cultivation under 4(2). Is that correct?
First time, as connection C, not D. Grant was made to the state. Tasika has not as this grant. Stay look, the grade 75 ಅಲ್ಲಿ. ಇವಾಗ ಜಮೀನು 23 ವರ್ಷಕ್ಕೆ ಗ್ರಾಮ ನಿಕಾಲ ಮಾಡಲಾಗಿದೆ. ಇವಾಗ ಜಮೀನು ರಸ್ತೆ ಪಕ್ಕದಲ್ಲಿ ಇವಾಗ ಜಮೀನು ಪಕ್ಕದಲ್ಲಿ ಜಮೀನು ಇವಾಗ ಜಮೀನು ಪತ್ರ ಬೆಳೆಯುವುದು ಕಂಡು ಬರ್ತದೆ. ಅಶೋಕ್ ಕುಮಾರ್ ಅವರು ಸುಮಾರು ವರ್ಷಗಳಿಂದ ಜಮೀನನ್ನು ಸಾಗುವಳಿ ಮಾಡಿದ್ದಾರೆ ಎಂದು ವಿಚಾರಣೆ ಕೇವಲ 10 ಗುಂಟೆ ಜಮೀನನ್ನು ಬಸವರಾಜರು ಸಾಗುವಳಿ ಮಾಡಿದ್ದು, ಉಳಿದ ಜಮೀನನ್ನು ಕಲಿಯಪ್ಪ ಸಾಗುವಳಿ ಮಾಡಿದ್ದಾರೆ.
This is not for better enjoyment. No, that is not the finding. This is the order. The AC conducted the spot inspection. Therefore, you can't come under 4(2).
The last of the kind report page internal page 30 of annexure J, that is order of page.
Page?
The J, page 104. Their order is the order against the client. And in so far as my client is concerned at para 37.
104.
104, para 37 of the case order.
ಯಾವ ಕೇಸಲ್ಲಿ ಹೇಳ್ತೀರ ನೀವು? Yes.
So far as claim of Basavada, the division petition in division number is concerned, there is no dispute that this petition is eligible for grant of land because very grant of 10 meters of land is 7 number 44 of Madi village itself indicates the petition Basavada is eligible for grant. Even there is no dispute that Basavada also made an application for grant. There is no doubt that the farmer on application given for grant of land is 7 number 44 Madi village. This petition has not stated the extent of land to be unauthorized cultivation. For grant of land, the person need not to be unauthorized cultivation of such land. Sought to be granted in land category. But from Bharam around 5 in Siddhamaka and Basavada do not disclose that they were unauthorized cultivation of land. This is Siddhamaka, it's my claim. Claim that since the land is other number, shown in Bharam application. Submerged and acquired is eligible for grant of land is displaced person. Whereas Basavada although claims the grant is surrender of part of Madhuri, they are not disclosed the extent of land sought to be granted in Survey. This shows that both of them were not in cultivation of land in survey number part of Madhuri. In such an event, in our opinion, the land has to be granted not only on the basis of promotional but also on the basis of eligibility. If they claim for a grant of land on the ground of unauthorized land is particular Madhuri, both of them are not eligible for grant of land more than 2 hectares. Deep class land includes of the lands already held by them as per the second clause of 1948 of the Land Revenue Act. If the nature and extent of land held by them is not taken into consideration, land already owned shown in the position of Siddhamaka and Basavada exceed the 2 hectares deep class land as per the evidence and documents are in Karnataka. In this also, both the Siddhamaka and as well as Basavada are not eligible for grant. So far as Karyappa is in the and Para number 39, both Basavada and Karyappa claimed that they were settlement lands in several years. Basavada, another applicant, claimed that land in several numbers 44 of Madhuri and the land situated adjacent to the land in this question. That's our claim. Situated adjacent to the land in the portion in survey number 45. He was in cultivation of land. If that evidence or a statement is taken into consideration, granting of 10 foot of land is also illegal source unauthorized occupation on the section. He was in holding theatre, 30 foot of westland, survey number 41 Madhuri. This fact has not been disputed. If the land is covered by the deep class land, it comes to 7 acre 90 feet exceeding limits unequal of 2 acres deep class land. It appears that this said Basavada and in question of 10 meters of land at the time of participation, said land has been granted. In view of our discussion, said land is also for the foregoing reason, the division should not be available.
So better cultivation ಹೊಸ argument ನಾಗರಾಜಪ್ಪ.
Adjacent to
ಹತ್ತು ಗುಂಟೆ ಅಲ್ರಿ, ಹತ್ತು ಗುಂಟೆ I will retain, but not more than that. That is not the finding of the AC. The order of the AC is that you are possession only of 10 guntas of land. You can't keep on enlarging it. And strictly speaking, the order of the KT is correct insofar as your claim is concerned. The implant is the Siddharama.
He has not established the road take for a grant under so much. He has not established that road. That's the reason you want road must be 86 and 87.
I have documented this document.
86 and 87. This is observation made by Lord.
Your observation is no.
ಹೇಳಿ
Page 86.
ನಿಮ್ದ್ರಲ್ಲ ನಿಮ್ದ್ರಲ್ಲ Where?
Para 10.
KT order.
Fine. In view of the grounds. Para 10 of the ADR. But
Yes.
in view of the grounds of revision petition, the revision petition number 65 and 66, mine is the lot 25. 65 and 66. The revision petition in the revision petition number 66 has shown sufficient cause for fundamental degree. Number 2, whether the expert produced the revision petition 65 exclude as evidence. The order included in the revision petition number 65 and 66 are sustainable. Whether the rejection of the grant made in favor of the petitioner in revision petition, that is in the respondent case. Reasons: petitioner in revision petition number 60 has been separate. While in support of the condition delay,
ಬಿಡಿ ಅದಲ್ಲೇನು ಬೇಡವಲ್ಲ.
para 30, the respondent also appears to assist
ಬಿಡಿ ಡಿಲೇಗೆ ಅಷ್ಟೇ ಅದು.
Relevant portion is that as per the same from the lower court record, all the officers are resting commission and claim put forth by the parties to these resolutions are one Siddhram. The father of the revision petitioner 65 to 66 was certain land and those lands were suffered in Shanti Sagar and therefore they are applied for a land of land. 8 acres and 741 claiming that it is a displaced person. It is clear from the application in form number 1 available at the sheet number so of the officer. After holding inquiry, the Tahsildar of Karnataka granted 3 acres land to the ABC survey number 44 village. The number so dated 31 was granted based on recommendation of land plans committee resolution dated 1982. Land within 3 acres granted in favor of Siddharamappa. Survey number 41 village was questioned by the respondent Aforesaid, who is a petitioner in the revision petition number 25 and carry up before the Action Commission revision application number 4. In the set up, the Siddharamappa was first respondent. The Action Commission having the matter allowed in those area numbers and by his order dated and cancelled the grant made in favor of Siddharamappa by the Tahsildar. It is clear from the order of the Action Commission.
ಪರ 27 ಓದ್ಬಿಡಿ ಸಾಕು, ಅದೆಲ್ಲ ಬರೀ ಫ್ಯಾಕ್ಚರ್ ಇರ್ತದೆ. ಪರ 27. 27.
The points involved in these questions are that whether Ashok Kumar is entitled to grant of land within 3 acres of land based as a whether the Basaraj is also entitled for grant of the remaining 1 acres and 1.7. They noted that it is around 5 number 1 on 28 and 18 for grant of land within 8 acres. This also state as per farm number available at sheet number the revision petition, revision 25 are also by application in form number 1. On 10/8/83 for grant of land, the survey number 44 as per the application available at sheet number but extent of land has not been mentioned. Carried upon the respond number 6, the revision petition number form number 1, application for grant of land within 1 acre as per order number 1 available at sheet number also therefore claims that he is a person belongs to scheduled caste for grant of land. Siddharamappa, the father of Ashok Kumar and farmer application, has stated that the lands in Savanamur also of Arsenigatta village of Telangana suffers in the Shansagar. To show the same, he is Siddharamappa, the father of Ashok Kumar, has produced the last complaint authority Great Bank Canal, this is important. At the outset, it may be noted that the Siddharamappa has not particularly the RTC or records to write to show what is the total extent of each survey number set to be merged in the Shantisagar Canal and Bhadra Canal. He has also not stated what was the extent of land in its position or portion of the survey number in each survey number. These documents are very much necessary to consider the claim as to whether he is a displaced person or not. Because recently, during the pendency of proceedings before authority in the year 2000, you show, it's very difficult to say either of the entire or a portion of the land survey number was upper division land or acquired for the purpose of canal. The estate executive rules that you have issued, this endorsement dated 18th and 1992 is also not stated in the land suppose in land or acquired for the purpose of digging canal. When you are able to use such an endorsement, you must be knowing what is the extent of land acquired for the purpose of canal. Moreover, as per the recitals of the endorsement, assisted endorsement based on entries mainly revenue record, not on the basis of the records maintained in the office. Such endorsement will have been issued by the revenue authority because it is the revenue officer collecting conduct for agriculture lands. If those survey numbers were really substantially then question of collecting revenue from the owners of such survey number does not arise. Therefore, the revenue officers who maintain the records concerning the agriculture land is the competent authority to issue such endorsement. Further, it is significant to note that as recited in the endorsement, the executing the entire lands of those survey numbers referred to the endorsement for supplementing the unstandard tax. If that's decidedly stated in consideration, we can say that no portion of those survey numbers remain unsubmerged. The entire lands of those survey numbers submerged in the land are acquired for the property. If that is taken into consideration, how can there be a apartment place in those survey numbers of don't show that will be able to run when the entire extent of those survey numbers submerged in the land are acquired for the purpose of canal, portion of not share to sharers does not arise. From this and from the circumstances, it can infer that legal economic made a false claim, claiming that this is stress a person into submersion of land in the tax. Therefore, no reliance can be placed on the endorsement secretary. So far as survey number zones are concerned, Indian petitioner, Ashok Kumar and Indian petition zones have issued a gazette notification of law by the Indian Commissioner. The Xerox copy of the gazette notification available in zone. So, as per the Xerox copy of the gazette notification available at street number zone. Then, AG Sidram and the show as part of the said lands measuring 20 meters. Number 38 was in cultivation portion of ground as per the entry shown in number 3 of the notification. Accordingly, the name of this ground was serial number songs for gazette notification. As per the entries made against serial number 48 and 61, it is ground of shown as to the lands measuring 29 meters in and 1 acre 26 meters proposed to acquire in certain number songs are but those lands were devotional and enjoyment of Malappa and shared respectively. As per the entry shown in column of the gazette notification, the entry shown in the column of the as per the certain number 13 part, 49 part, and 44 part are taken into consideration. Said that the applicant was not the owner of those lands, merely because the author has been shown in the name. It is very difficult to hold that he was one of the lands as the person was acquired those lands by any means. They cannot have got the Kata change in their name, in your opinion. But Anubhav normally we use only when the lands were in possession. And if it was in cultivation the other than the owner normally, the word cultivation would be used in making it. This supported by the entries made against serial number also. It is Sidram was shown as both Abedar and Angola. Really, this said it is Sidram was in Angola. His name was also shown in the column against serial number 14 for 861. That was at it is Sidram accuracy the document. Evidence in the receipt of the compensation from the concerned authority would have been helpful. If no such endorsement issued by the land acquisition officer, the court which had favored the referred rating of the land acquisition act are produced, then it can be read infer that lands in certain lands of the agency not mentioned in Sun's land are acquired for the purpose of the people. land is usually considered in the survey number 40/11, and it is the only land acquired by the government. Therefore, in New York circumstances specific, not only declared for us to hold the system of a displaced person with submission of lands by the purpose of that. Also, different what with the results of the response to 123 that the system can have produced any documents that lands for acquired for submersion in this concern and observation that no relates in the case on the document should be tested. Besides that, the system has also not produced the document to show that survey number 83 and 82 or 80.
Can they do all this? ಹೇಳಿ ಹಿಂಗ್ ಮಾಡ್ಬೋದಾ? ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ SLO, ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ. Can you doubt all that to say that he is not a displaced person?
Establish that the Lord then is
What more do you require than the SLO's endorsement?
not only single document produced, so nor my Lord the compensation. Received for
He has proceeded the gazette notification, the endorsement of the SLO.
and this is also and the land is granted by law.
Tell me.
Whereas will not be sold subsequently.
I'll maintain 10 guntas for you, 1 acre 20 guntas for the other person. Remaining will go to him, 1 acre 10 guntas.
Like record to tell
Madam.
like record to tell and
An extent of 3 acres in survey number 44 of Malali village. The subject matter of these writ petitions. Next, madam. These facts are not in dispute. On 12/11/1982, facts will correct again. On 12/11/1982, the land grant committee recommended grant of 3 acres to A.G. Sidramappa on the ground that he had lost his lands due to submersion. Next, on 31/5/83, on the basis of this recommendation, the Tahsildar granted 3 acres to A.G. Sidramappa and the revenue records were also mutated. Next, however, on 7/10/85, the grant made in favor of A.C. Sidramappa was cancelled when it was challenged by respondent numbers 5 and 6. ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿದ ಅದನ್ನ? Who's 5 and 6? By Karibasappa. ಬಸವರಾಜಪ್ಪ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಕರಿಬಸಪ್ಪ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. By Basurajappa, bracket ಅಲ್ಲಿ R5, and Kariyappa, bracket ಅಲ್ಲಿ husband of R6. So, this order of cancellation was also confirmed by the Deputy Commissioner. So, the Karnataka Appellate Tribunal, however, set aside this order on 25/2/88 and remanded the matter to the Assistant Commissioner. Next, on 5/3/1991, the Assistant Commissioner on remand proceeded to reject the claim of A.G. Sidramappa, and this was also confirmed by the Deputy Commissioner on 5/6/1997. Next, consequently, WP 23-104 of 97 was filed by Sidramappa, and this writ petition was allowed on 26/8/1997, and the matter was once again remanded to the Assistant Commissioner. The Assistant Commissioner, by an order dated 26/6/1999, remanded the matter to the Tahsildar. On remand, the Tahsildar proceeded to reject the claim of the petitioner and proceeded to grant 1 acre 20 guntas in favor of Kariyappa. The said order was challenged by the petitioner as well as by Karibasappa before the Assistant Commissioner. The Assistant Commissioner, by an order dated 10/6/1991, confirmed the grant of 1 acre 20 guntas in favor of 2001. Proceeded to confirm the order of grant made in favor of 1 acre 20 guntas in favor of Kariyappa. He also came to the conclusion that R5 Basurajappa was in possession of 10 guntas of land, and he accordingly proceeded to grant only an extent of 10 acres 10 guntas in favor of Basurajappa, alva? Basurajappa. In fact, the reasoning of the assistant commissioner are in the following terms, page 75 mark portion. Being aggrieved by this, both A.G. Sidramappa as well as Basurajappa preferred appeals to the deputy commissioner. The deputy commissioner, however, by an order dated 13/11/2002, dismissed both the appeals. Next para. As a consequence, A.G. Sidramappa and Basurajappa preferred an appeal, revision alva? Revision to the Karnataka Appellate Tribunal. And the Karnataka Appellate Tribunal, by the impugned order, dismissed the revision filed by Sidramappa. It also proceeded to dismiss the revision filed by Basurajappa, and in fact, it proceeded to set aside the grant of 10 guntas that had been made in favor of Basurajappa. Practically, it may be pertinent to state here that the names of the original grantees are mentioned, though they were no more, and their LRs were prosecuting the proceedings. It is as against this order for this court. Similarly, challenging the cancellation of 10 guntas of land granted in favor of Basurajappa, his LRs have also filed WP 48032/2021. Next para. The Karnataka Appellate Tribunal has basically cancelled the grant as rejected the claim that the endorsement that was relied upon by Basurajappa, by Sidramappa, issued by the assistant engineer to show that his lands were submerged, could not be accepted, since in a subsequent partition of the year 2001, the very same lands were also the subject matter of a partition between his wife and his other family members. The assistant commissioner, the tribunal, has observed that in the absence of the entire extent of the lands in question, it would be improper to concur with the assertion of Sidramappa that his lands had been submerged. Secondly, the tribunal has also found that it could not rely upon the gazette notifications which were produced to show that the lands of Sidramappa were submerged, because in the cultivators column, his name was not indicated, and there were also no records to establish that compensation had been paid. Next para. In respect of the claim of Basurajappa, it has found that he was not entitled for grant of 10 guntas of land, since he was already in possession of certain lands, and if they were taken into consideration, as a ceiling in the land grant rules. At the outset, it must be stated here that when the concerned land acquisition officer had issued an endorsement that Sidramappa had lost his lands due to submersion, the Karnataka Appellate Tribunal could not have gone into the question as to whether A.G. Sidramappa had actually lost his lands due to submersion. The Karnataka Appellate Tribunal could not have microscopically examined as to whether all the lands or a portion of the lands of A.G. Sidramappa were submerged, so long as the competent authority had issued an endorsement that the applicant's lands were submerged, the Karnataka Appellate Tribunal and as well as the granting authorities were bound by the said certificates. It must also be pertinent to state here that gazette notifications were produced to indicate that the lands of Sidramappa had been submerged. In fact, even before this court, revenue records are produced to indicate that Sidramappa had indeed lost lands due to submersion. If A.G. Sidramappa had lost lands, it cannot be in dispute that under the land grant rules, he would be eligible for being granted land on the ground that he is a displaced person. However, this aspect of the matter has not been considered in the proper perspective. Next, it must be pertinent to state here that the grant made in favor of Karyappa, that is to next to 1 acre 20 guntas, cannot be disturbed because Karyappa is stated to belong to scheduled caste and scheduled tribe and was also a landless person. In that view of the matter, the claim of Karyappa to the extent of 1 acre 20 guntas stands on a higher footing as compared to the claim of either A.G. Ramappa or Basurajappa. Consequently, the tribunal was justified in confirming his grant. So, however, in respect to remaining 1 acre 20 guntas, in regard to the fact that the Assistant Commissioner, after spot inspection, had concluded that Basurajappa was in possession of 10 guntas of land, the tribunal could not have set aside this extent of 10 guntas of land. It is also to be noticed here that this 10 guntas of land was abutting the land that was already owned by Basurajappa, and therefore this grant of 10 guntas for better cultivation of Basurajappa's extent cannot be found fault with. Consequently, to this extent, the order of the Karnataka Appellate Tribunal setting aside the grant made in favor of Basurajappa cannot be sustained, and consequently WP 48032/2021 is allowed, and the extent of 10 guntas granted in favor of Basurajappa as per the order of the Assistant Commissioner is confirmed. Insofar as the remaining extent of 1 acre 10 guntas, in the light of the aforementioned fact that A.G. Ramappa had in fact lost his lands due to submersion, and this was evidenced not only by the endorsement issued by the SLAO but also by the Gazette notifications. In my view, it would be just and proper to direct the authorities to grant A.G. Ramappa or his legal heirs this remaining extent of 1 acre 20 guntas in cell number 44. Accordingly, the writ petition filed by the LR of A.G. Ramappa in WP 19755/2013 is allowed to this extent.
May I make a submission, my lords?
Please wait for a minute.
Please.
ಏನ್ ಮಾಡ್ಬೇಕು ಏನ್ ಬೇಕು ನಿಮ್ಗೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಏನ್ ಮಾಡಬೇಕು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಯಾವುದು ಆಫ್ಟರ್ ವೆಕೇಶನ್ after vacation 90 after vacation 116 ಅವ್ರಿಗೆ ಇರ್ಬೇಕಲ್ಲ ಅರ್ಜೆನ್ಸಿ
That's serial number 81, my lords.
1 minute, madam.
Please.
Day after tomorrow, madam.
My lords, can it be taken on 25th, my lords? There is some inconvenience on 23rd, my lords. 25th, my lords.
They opposed the adjournment because you are not there adjourned to.
Let's, it may
Please be
pass
available.
on, my lords. My lord, it may be taken in the afternoon, my lords.
Not
I'm
now.
ready to.
Not now. You should have been there when the case was called.
There were some internet issues, my lords.
40?
My lord, serial number 99, my lord.
Serial 79. 79. ಏನು ಸರ್ 23ಕ್ಕಾ 17 ಏನು ಸರ್?
23ಕ್ಕೆ
Sir, serial number 103 time ತಗೊಂಡಿದ್ದಾರಾ? 103.
Court officer serial number 114.
ಫಾಸ್ಟ್ ಮೇಡಮ್ ಅದಿದೆ.
Sir, 114 adjourn ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ.
Sir, 114 adjourn ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ ಮೇಡಮ್.
Okay, thank you.
ಯಾವ್ದೋ ಒಂದ್ 2-3 ಹುಡುಕ್ತಿದ್ರು ಸಾಹೇಬ್ರ
ಸರ್
ಇದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿ.
ಫ್ರೆಂಡ್ಸ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಚೆಕ್ ಮಾಡೇ ಮಾಡ್ತಾರಲ್ಲ ಎಲ್ಲೆಲ್ಲಿ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಸರ್ ಇಲ್ದಿರ ನಾವು ಸಬ್ಮಿಟ್ ಮಾಡಕ್ ಆಗ್ತದೆ. ಇಂಟ್ರಿ ಮಾಡಿ ಇಲ್ದಿರ ಸಬ್ಮಿಟ್ ಮಾಡಕ್ ಆಗ್ತದೆ ಅಂತ.
ಅದೇ ಹೇಳ್ಬೋದ್ರಿ.
ಸರ್ ಅವ್ರ ಟೈಮ್ ತೊಗೊಂಡ್ರು ಸರ್ ಸಬ್ಮಿಷನ್ 17 ಅವ್ರು ಯಾರು ಟೈಮ್ ತೊಗೊಂಡ್ರು? ಅಲ್ಲ ಯಾರು ಟೈಮ್ ತೊಗೊಂಡ್ರು ಅವರು?
ಯಾವ್ದು ಹುಡ್ಕೊಂಡು ಮೇಡಮ್ ರೆಕಾರ್ಡ್ಸ್
ಇದ್ರಲ್ಲಿದ್ಯಾ? 79 after vacation.
Sir?
After vacation.
20 after vacation.
Password.
ಇಲ್ಲ ಸರ್ ಅವ್ರು
ಇಲ್ಲ ಇರ್ಲಿಲ್ಲಲ್ಲ ನೀವು.
ಸರ್ ಅವ್ರ ಟೈಮ್ ತೊಗೊಂಡ್ರು ಸರ್ ಅದರಲ್ಲಿ 79 ಟೈಮ್ 23 ಅಂದ್ರೆ 79 ಅಂತ
79 after vacation.
ಆ ಟೈಮ್ ಅವ್ರು ತಗೊಂಡ್ರೆ ಹೇಗೇನು ಸರ್ ಅದನ್ನು?
ಈ ಕಡೆ ಇರ್ಲಿಲ್ಲ ಅಲ್ಲ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಯ್ತು. ಪಾಸ್ ಓವರ್ ಕಂಪ್ಲೀಟ್.
ಹಲೋ
ಪಾಸ್ವರ್ಡ್ ಜಾಸ್ತಿ ಇದೆ
ಮಾಡ್ತೀವಿ ಮತ್ತೆ ಇವಾಗ ಯಾಕೆ ಬಂದೆ ಚಾ ಕುಡಿದಲ್ಲಿ ಓಕೆ ಓಕೆ 26 ಇತ್ತ ಅದು ಆಯ್ತು ಮತ್ತೆ ಆಗ್ಬೇಕಾ ಫಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. ಆಯ್ತು ಹಾಗೆ ಮಾಡೋಣ. ಬಟ್ ಅವರು ಬರ್ತಿದ್ದಾರೆ ಅಕಾಡೆಮಿಕ್ ಕೌನ್ಸಿಲ್ ಮೀಟಿಂಗ್. ಹಾ
and annexure B. Based on the general complaint record start says that there was survey number 4 and owner of annexure B is 8 acre 20 meters. Survey number 4. They say that I am owner of 4 acre 35 meters. However, in excess another 4 acre 10 meters portion of the property that 4 acre 10 meters.
AG accepts notice for respondents. Objections if any in 2 weeks. There shall be a stay of all for the person pursuant on next year. Who are you?
I'm the original owner of the land, in possession of the land.
Original owner andre henge.
I have purchased 2 acres 20 meters of land from earlier owner.
When did you purchase?
That's 90C annexure E by movement.
Next year?
Annexure E will page 47. This is the sketch prepared by the other surveyor for Australia's scheme, reserved for Australia. Then there's kindly come to
No, but survey number 64 is a large extent, isn't it?
32 acres of land is open in the office. Kindly come to annexure R1 minutes, take 50 minutes. Google map. Sketch here identified us. Which is in my possession of property.
Now, what is there to show it is in your possession? ಯಾವ ಪೋರ್ಷನ್ ಎಕರೆ ಇಲ್ಲಿ ಈ ಸ್ಕೆಚ್ ಪ್ರಕಾರ ಹೋದ್ರೆ ನಾರ್ತ್ ವೆಸ್ಟರ್ನ್ ಪೋರ್ಷನ್ ದೇ ರಿಸರ್ವ್ 2 acres. How do I find out which? ಇದ್ರ ಆಧಾರದ ಮೇಲೆ ಹೆಂಗೆ ಏನ್ ರೆಡಿ ಅವ್ರೆ? I can't go with this. No, is he in possession? What is it to show that you're in possession?
I have RTC minutes of annexure A minutes.
Next year?
Annexure A.
ನಿಮ್ಮ ಹೆಸರು ಇದೆಯಾ?
Now, file representation also does.
Where is this MR2/0506? You purchased on a sale deed, huh? But let him take notice, let us see, because you are challenging him. No, I'll get him, let him get instructions, because this is an order of the year 24, February 24, 1.5 years ago. Without hearing them, I can't really pass. Day after tomorrow, happalla. AG accept notice for respondents. Relist day after tomorrow. Who appears for R6? T was ready. Ian Agjapa takes notice for R6. Day after tomorrow. Day after tomorrow. Relist in primary. Day after tomorrow. ಏನ ಮಾಡಿದಾರಾ? State Coastal Examined Office to verify. What are you challenging here?
What happened was purchased by 4 acres, 16 gutas. Purchased by my father responsibility. I want to take time.
Pastor model time ತಗೊಂಡು. Vishnu sir. What are you challenging?
But a lot of the land figures are granting occupancy, saying to have granted occupancy rates in respect of not the scheduled properties in favor of certain individuals. But I was not made a party to those proceedings. In fact,
You challenging order of the year 76 sir.
Yes, sir. Yes, sir. But what happened was these are indoor lands not in favor of the people. Only 2023 law, a complaint was made that lands which are indoor to the not temple is in India, India is not temple. These lands are in a village in Mysore. The complaint was made that lands which are indoor to the temple are being used by third parties, without their knowledge. Then not an inquiry was instituted. A committee was constituted to go into the history of this land. Then not a report was filed, showed that the land belonged was indoor to the temple. The record of rights, not index of land, shows the name of the deity, without making the deity a party or even the temple a party. Some of the logic see the order not passed with land to in fact, it is written with God. The logic says page 36. Person who files initially not the form is somebody else. The order is granted to somebody else. There is a subsequent order not is these lands are included. The original proceeding started with certain other lands. Thereafter, for 26 years, this land tenure order did not see the light of the day. Foreign time was never issued. Names were not entered in the RTC. Now in 2002, for the first time, they entered their names in their RTCs, not claiming on the basis of order. Can you take page 36 from election 8?
No, they have shown some.
Yes, some related parties.
And what is there to show that you are the owner of this
The
property?
RTC index of lands recorded by all of them show.
Show me the RTC of 7374.
Yes, sir, from 7172, approximately 2022, but page 100. Without priority,
What is the extent of land involved?
but there are around 14 acres to the gutas. Normally, what happens is they make a claim for portions, not about 9 acres, 26 gutas, they make claim a portion of it. That portion seems to have been granted in their favor.
Which?
But page 100.
No, show me the RTC for 7074. 100 is ILR.
101, 71, 72, 75, 76. But we turn to page, there are no page 102. At the bottom right left, they want to find out with black and white was lost. But what you see what engines over is 399. I want to take 104 words clear there. Therefore, take 7 lines from the what you find the bottom left.
Page? Page?
104. Bottom left. And I have produced subsequent RTCs also. They also continue to show the mining.
Again, madam, you appear for?
No, they have all now sold after the reinstituted proceedings. But after realizing this, but in the meanwhile, not in 2024, not they have purchased the lands.
But they are not the owners of the land. They have no right over this. But please tell to be 112. It's a P. According to their own, not a P. That's right.
Yes.
This was submitted since temple was signed in the devotees. Some of the devotees came forward generously and donated the land to the devotees to cover daily use
So there is no gift deed in your favor.
There is no endowment, but endowment not lordship seats.
On what basis do you say that?
There's a lordship seat, the mutation. But I just talk about the. Kindly take note that. The mutation entry which not they rely upon. Kindly turn to page 92. To show what the mutation itself says, it is on some statement given by somebody, the son of not one of the landowners, that it is to be given not to the temple. And what is what page. This is a copy you are doing, right copy of the document which they have, page 6, and serial number 535 on the left hand side. Mail report to Jyoti Swami Devaru. Not have it. So please see what is mentioned there. Number to the E Devara, why to do so? Because this Devara save working today order. Arthavadi, Uttevudaki, Mane order order, Muskuru, government the Tidu Mangal today. But then please see the next column. Next row. You are going to each of the Pustical Pustu. There are Utpatti in the Devara Seva Medicine, bypass the income that is generated from the property which is given to on lease. All good done in the statement. But I am nowhere his name enters in the record.
No, but I'm still unable to. What is your rate? Because if this mutation is taken into consideration, it's not an endowment in the sense that you made out to be. This indicates that the lease amount that was being derived for the cultivation of these lands was being given to you for certain purpose, but it does not make you the. No, an entry in the revenue records by itself will not confer ownership on you. From 76, if there was an endowment, what is there to show that you are? All right, from that date, what is there to show that you are exercising this endowment for the religious purpose?
Yeah, it is not been used because it is not known. Lordship is not, temple authority is not, this is not temple property or user.
No.
That does not, once it is an endowment, but by user, it cannot be divested. And
This statement at page 6 does not indicate that you are the owner.
It's an endowment.
Kindly read it once again for my benefit.
I have also put it like
535 and 536.
page 92 not have produced.
Which you want me to take? Yours or this?
I also put it like, I am not sure why my letter is not to produce something else. I have basically put it like that. Kindly take not page 92.
$90. Yes. Typed copy is at 92. It starts up with 537. You will quote 535 and 3.
But there are different survey numbers. You have to find the survey numbers not mentioned in the third one. So these numbers are the two. They were very good. They were a single. Borevada, Borevada, Bose Borevada, Dharmavadi, Kotivadagi, Andre Borevada, Bose Borevada. But it is not converted because the first time recorded in 1970s.
No. Kindly read the next column.
Yes. Survey numbers 397.
The next column 538. ಇವರು ಈ ಜಮೀನನ್ನು
538.
ಗುತ್ತಿಗೆ ಕೊಟ್ಟು ಇದರ ಉತ್ಪತ್ತಿಯನ್ನು
ಈ ಜಮೀನನ್ನು ಗುತ್ತಿಗೆ ಕೊಟ್ಟು ಇವರ ಉತ್ಪತ್ತಿಯಿಂದ ದೇವಸ್ಥಾನ ನಡೆಸಿದಂತ ವಹಿವಾಟುದಾರರಾಗಿರುತ್ತಾರೆ. That is not they are taken, they are using it, cultivating it, but they are not a party in the LR.
It's all right, but you are not the concern.
This is an endowment in my favor.
That I don't consider this to be an endowment in your favor because this statement is on the basis of somebody else's statement. There is what is there to show? This is referring to Boregoda Makkalu, Gosegoda, Tilu Bandirtade. Who are they? Out, and on what? If they come forward to the court and say that this order is obtained behind our back, so they are not before the court. I am not. Apart from this, I will consider judgments. Apart from this, anything to show that there's an endowment, apart from this particular revenue entry. So apart from this, there is nothing. You have not exercised the right of ownership in any way.
At that point, it will be. That's how it has been done. Now, what the Rashid says in 23, I will not be able to find record not of 1970.
See, if this entry was made on some solid basis, I can have some.
From page 91 to 91, but I'm talking about the record of rights, which gives all of these 7 numbers. These are the type copies from 92 to 94. Then you have a look at the index of lands, which is at page 96. Kindly see what the person in position of so and so, column 7. Page 96. Next L. Kindly see what under column 7. Mail report is page 96. Before that is the record of rights. Next is what the index of rights.
Page 90, a typed copy.
96 minus 98 is typed copy. You have to find what mail report is from Devu. Mentioned this. Again, what the same reference is made. Then kindly see what the subsequent RTCs also, which are produced.
But this is obviously the basis of IL only. This entry is on the basis of the IL.
Now what the Rashid is the very same record on the basis of which they are relying. I point you that.
No, I will come to them afterwards, rightly or wrongly, Srinivas. They have an order granted to them about 50 years ago.
They have a order. This is a fraudulent order.
No, we will assume that for a minute it's fraudulent. But I'm only questioned about your right to challenge this after 51 years. No, show me if that's an endowment. On this statement, I'm not prepared to accept it's an endowment.
But I produce judgment not to say that a statement in the RCC by the landowners saying that the rents are meant for use creates an endowment. It need not be by way of a
It should be substantiated by some other document too.
Sufficient. But there is judgment of the Supreme Court on that aspect. We would slow. We just take what 1957 what the Supreme Court. But of course, the Russian notes not now the same concept of user for a religious endowment, which is made in favor of a temple. Even user or entering the record of rents is sufficient.
Now, please come to the first page. They considered that the properties in their rents were subject to the charge in favor of the charities, but they denied that the said properties were the subject of charitable trust. So that was a completely different situation. So I don't think.
Point out the principles of law. Just lot of permit will not insofar as non-charitable endowment. Lot would find that we just point out that a mere entry in the notation is also sufficient to infer blood endowment.
He's good.
I'm sorry, but I could not make copies immediately. The earlier judgment, you also see para 6.
Where is it talking about revenue entry?
But the earlier, the judgment is not a 46, not the judgment. I just find out about the entry also. Can you take para 6? Maharani Hemant Kumari's Devi versus Gauri Shankar Tiwari. The judge ranking given to the board has observed the usual case of complete litigation made to an idol. For example, the property ceases altogether to belong to the owner and becomes vested in the idol as a used person. Complete relinquishment by the one of his property right is covered by no means the only form of education known to Hindu law, and is very different from anything that could ordinarily be inferred from the public user of a highway. From the standpoint of Hindu law, it is not essential to be a valid education that the legal title should pass from the owner, nor is it inconsistent with an effectual education that the owner should continue to make any and all uses of the land which do not interfere with the uses for which it is dedicated. They will not, even though he does not divest his ownership.
Let us test your argument. I give you an endowment. You are entitled to use that property for your purposes. You must establish that it was first endowed to you. For that, your answer is this particular revenue record. If once that is endowed to you, what is the next thing that you have to establish?
I do not have to establish. Endowment
So you can just sit quiet for 51 years, allow things to pass, and then get up one fine day and say no. It's not adverse possession. By your own documents, the land was tenanted. This IL indicates that the land was tenanted, and out of the tenancy lease amounts that they got, that was being given to you. Therefore, the fact that it was a tenanted land which should vest in the state can't be in doubt at all.
So far as can we see the order page 36? Can we see the order page 36? The persons against whom the proceeding, this is a fraudulent document.
I'm going by your documents. I'm not going to order land tribunal. Your own documents indicate that the land.
Not as of 71, not as of 36. On 31/3/74 it should be established.
That's why I said if that is so, if you had some other document to show that as on that particular date you were exercising the right and you had not leased the property, I am not.
Page 36.
Yes.
Can we see the affiliates on top? Panumaya, Ramaya. Then you also see Chikkaboregoda, Devamma, Venkatesh Vitharos. Then can you see the paragraph below? SRA Grammar survey number 388. It pertains to some other survey numbers, not mine at all. So on suddenly, Uttigadar last line not in the paragraph. Panumaya, Ramaya, Tempaya with Puttaswami into E-Mulaka forces the life. Srimati Devirama Venkataya notice to put to so also moved alike. So when this order speaks as if it is granted and then notice is issued.
No, that is, I'm going to the merits of the claim. I'm not prepared to examine the merits of the claim of an order of the year 76. I can't.
Now that is being set up against me to say.
I am not convinced about the fact that there is an endowment in with you. Assuming there was an endowment, your document that you rely upon indicates it was tenanted. Therefore, you can't have a better case if your own document says it is tenanted. So you lost all that rights over that land.
No, I would not. Because as on 31/3/74, not only here to best, it is tenanted. Not otherwise. Number the records speak earlier they were to lease it out and use the for mining festivals. But now there is no finding.
If there was some document to show from 76 or from 74, you were utilizing this lands or the money that it came from these lands for some purpose, I can establish. You are completely silent on that. So, ಬಿಡಿ ಹಂಗಾರೆ ಆಸೆ ಬಿಟ್ಬಿಡಿದ್ರೆ 51 ವರ್ಷದ ಕಡೆ ದೇವಸ್ಥಾನ ಬಿಟ್ಬಿಡಿದ್ರೆ ಇವಾಗ ಯಾಕೆ ಎದೊಳ್ತೀರ ಇವಾಗ? But you should have been careful. You are taking care of God and you can't take care of the properties.
Just read one paragraph in this one. An express dedication can also be made orally. No special form or words are necessary for that purpose. An express dedication is made by word of mouth in a property limited to of a deity or a charitable purpose through a ceremonial dedication. Then the ceremonies are sankalpa and samarpana. An infinite dedication is inferred from conduct of the owners of the property presumed to have been dedicated and from immemorial use of the property. The question of infinite dedication becomes important only when a claim that the property is secular or a sectional or a private person set up against private claim on behalf of the public.
See, Srinivas, that document, if it was indicated that the owners had given the statement, that is one thing. The word here they used is very ambiguous. ತಿಳಿದು ಬಂದಿರುತ್ತದೆ ಅಂತಂದ್ರೆ I can understand ನಮ್ಮಪ್ಪ ಇದನ್ನ ಕೊಟ್ಟಿದ್ರು ಅಂತ ಹೇಳಿದ್ರೆ ಅದನ್ನ ಬರ್ಕೊಂಡೇ ಒಂಥರ ಅವ್ರು ಹಿಂಗ್ ಹೇಳುದು ಅಂತ ತಿಳಿದು ಬಂದಿರುತ್ತೆ ಅಂತ ಅನ್ನೋದು ನನ್ಗೆ. So
They have asked it at a time. Therefore, the children who are the legalists are making this security recorded. The RCC may just make that sentence not be just point out. But you see, it is not necessary for a valid dedication. The legal title and possession should pass from the owner. Nor is it inconsistent with the ineffectual dedication. The owner should continue to make use of the land which does not interfere with the purpose. What is it? Exactly not the words which are being used by the Supreme Court in the judgment. Then what complete relinquishment by the owner is not the only form of dedication known to Hindu law. Then we also have a not on so far as mutation entries. But the nature and extent of dedication have to be considered in case of non-availability of material to own express dedication, either in the shape of a document or in the shape of ceremonial relinquishment. Even if evidence of an express dedication is available, it can be necessary to determine the scope of such dedication, whether it is for the entire public or a section of the public also. Then you also have a not in so far as the existence of an idea to which the property could have been endowed, that the members of the public visit the place. These are not matters by which not endowment can be inferred. By proving the statements and additional parties in any made earlier, then what you also see, in so far as mutation, we just want to point out, divestment of ownership may be evidenced in several ways. Mutation of claims is one such proof of divestment. But we just point out that
I told you, if it was on the basis of the statement of the landowner, I would have been with you. That is not the import of that particular statement.
Just not point out, we just read the statement again.
Yes.
But this they were not Rashid notes. Ultimately, these records were in existence even much earlier to the 31374. I'm sure you not recorded rights from earlier, index of land from earlier, and RTC of earlier.
This entry should be corroborated by some other material on the base.
Not Rashid says entry.
No, I'm not.
But there's a presumption of the entries in my name. My name has continued not from 1962 from what I can get now.
If the statement was by the owner, you're right. This is not the statement by the owner, or this is not a record of a statement made. This is against your argument that there's an endowment. This is an observation by the revenue officer for making the entry. I am not prepared to accept it. ತಿಳಿದು ಬಂದಿರ್ತಲ್ಲ ಒಂದನೇ ಬರ್ಬಿಟ್ಟು ಮಗ ಬಂದು ನಮ್ಗೆ ಹೇಳ್ದ ಅಂದ್ರೆ ಬರ್ಕೊಳ್ತೀನಿ. ಆ ತಿಳಿದು ಬಂದಿರುತ್ತೆ ಅಂದ್ರೆ ಇಟ್ಸ್ ಇಸ್ ಪರ್ಸನಲ್ ನಾಲೆಜ್. He would have categorically said, as per the statement of the owner's son, she so and so, this has been dedicated. I would have accepted that. This ತಿಳಿದು ಬಂದಿರುತ್ತದೆ ಅನ್ನೋದು I am not.
ಧರ್ಮಾಂತವಾಗಿ ಕೊಟ್ಟಿರುವುದಾಗಿ ಒಂದನೇ ಗೋಡೆಗೌಡರ ಮಕ್ಕಳು ಗೋಸೇಗೌಡರಿಂದ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. That is the person making the entry is recording the statement of the legal.
He would have simply said, this entry is being made at the request of the son of the landlord, who has stated he has dedicated the land to the temple. And in the absence of any document to show that you have used any form of this land for 51 years. You have no record. You have no record from your sources to indicate. No.
114. Next.
Yes.
My name continues to be shown in column 9. Can you take page 114?
Yes.
Next section. People's names keep entering here without a form then being issued. So even the very RTC which they not rely on shows me in the column 9 entry. My name is shown and this continues to not Rashid sees. Thereafter, till 2002,
what they get this content, then they approach the Tahsildar, because not all the whole of the lands not are given under the land tenure order. For part of the lands, there is subdivision made by the Tahsildar. Part of the lands, my name continues, because even though the whole of the lands are not taken by the landowner, and Tahsildar records it. And then thereafter, he puts it, he thinks it's an inam, covered under the Inam Act. And thereafter, says enter the name of the government. Again, the DC also that is wrong, because the Inam Act does not apply to this. Therefore, I have come in appeal insofar as entering the name of the government for the balance of the land. Insofar as this, because there is a tribunal order of now relying on, which tribunal order is apparently fraudulent, because kindly see the form number 10, form 7, which was filed for this proceedings. Kindly see the form 7 right at page 45. Form 7 is filed by somebody else altogether, not these persons. How these proceedings could end up not Lordship sees from page 36. There is a recital of some other survey numbers insofar as LR 997 is concerned. It did not give these survey numbers at all. Form 7 is claimed is filed by somebody else who is not concerned with these persons who are not claiming. Now we have temple lands are certainly not usurped according to by virtue of this. My submission is there is no dispute about the names having been entered in column 9 right till not 1989-90 or thereafter also. In column nobody has questioned it. Even these people have not questioned it. But what they do is in the land record proceedings, somebody else, not even that Kose or whatever they had been shown as the owners, something would have been made of it. That the persons who had made the dedication, they have been made as parties and they have.
The burden is on you to show that the land was standing of Gosegoda, and thereafter. Show me in the island or Gosegoda's name was shown.
But when you see what the index of lands, when you turn to page what
There's nothing.
96. Can you turn to 96? What you find at Gosegoda is also. On the other hand, what let us see this aspect. What on what basis is the tribunal record of it? They are telling or cultivating the land. Nothing. New material. Kindly see what there is nothing. No material now available to show. These persons who are now not claiming the land, they were cultivating this land. Their names are found in column in the RTC. As on cultivating this or even not the persons whose names are shown as owners. They are the owners. Some two persons' names are shown and the proceeding itself starts against some other survey number. Form then filed by somebody else. An order is known. This very genuineness of this order is in question. Whether this land tenure order can be taken to be genuine, because Form 7 at page 45 is filed by one Kempaya, not by the four persons in whose name the order is granted. And insofar as the proceeding starting order, it is in respect of some other survey numbers. And there is an initial paragraph which declares them to be owners. And then it says notice is issued. Subsequently, the next page, suddenly what the sees page 37. There is a subsequent addition here by saying that Arjuna Raju, Kedare the survey number on my numbers 393, 397, 398, 399. Kutika Arjuna Kutika Venkatesha, who is Venkatesha? How is he connected with this land? He was shown as the owner insofar as all the other survey numbers. On the basis of his statement, but my submission is that this is the case standard of the authority not to show that even a mutation entity is sufficient to create an endowment. But once it is endowed, I cannot be diagnosed, I'll assume for the sake of argument that I did not use it or I do not have document at this point to show. That does not divest me of my right.
I am not able to satisfy myself that there is an endowment on the basis of the document that you have produced.
But this is the document is available, and the authorities which show that these documents are put unchallenged, but
the petitioner is challenging an order of the land tribunal passed on
but at least also would not observe. So other portions of the land is anymore not remain in my name because
no, once you argue, I have to consider something. On what basis do I dismiss your petition?
These lands not which they are claiming. Other
You-
lands are there, the balance extent.
You invite me to pass an order. Now you're saying don't make an
I
observation.
have to make a because that the temples stand and it is the
It's entered to you.
Challenging an order.
But I would humbly submit that not this adjudication is not required by your lordship. Because ultimately, if it is a question of fact to be proved, then what I also have, because of my name entering the record of rights, index of lands, all those particulars, even as of 1974, the land tribunal's duty would have issued notice to me without noticing that my name appearing in the RTC. But whatever be the nature of the right, I have to have been given notice. Inquiry had to be given. Then I would have not had an opportunity of putting out my case. Is not what I would submit to the government court. But this government court is not invited at this stage to not pronounce on the nature of my right in the light of my name having figured in the RTC in the index of lands, showing some sort of right, whatever it be, even to the usurer. Then what I ought to have been heard. I ought to have been made a party as a person being interested in the land, whatever be the nature, immediate nature of the interest, and then only not the order.
It's not on 17/6/1976, by which the land tribunal has conferred occupancy rights on the tenants. It is a case of the petitioner that the land was endowed to the temple, and though the revenue records stood in the name of the temple, the land tribunal, without making the temple as a party, has proceeded to confer occupancy rights. It is therefore contended that notwithstanding the fact that the order was passed in 1976, the petitioner was entitled to challenge the said order the moment it came to their knowledge that their lands were sought to be granted to the so-called tenants. Next, Learned Senior Counsel also sought to advance arguments on the merits of the order passed by land tribunal and contended that the entire order passed by land tribunal was a clear case of fraud that had been practiced on the tribunal, and the very passing of the order could not be sustained. As could be, so the basic argument of the petitioner is that the land was endowed to the temple, and therefore the temple was required to be made a party, and the endowment is also evidenced by entry in the revenue records. So, the temple has produced the IL and the RR, which admittedly form the basis for the entry of the name of the temple in the revenue records. The said entry found in the IL and RR reads as follows: 535, 536. It is not in dispute that the entries in relation to all the survey numbers are verbatim. So, as could be seen from the above, the entry that the land was endowed to the temple is based on a statement, is based on information that was stated to have been obtained from the son of Boregoda, children of Boregoda, that is Gosegoda. In other words, the entry in the IL and RR is obviously made on the information that has come to the knowledge of the person who made the entry. It is the entry in the IL and RR are not on the basis of a statement given by the owners or by their children. In my view, since the IL and RR does not indicate by itself that there is an endowment in favor of the temple, the argument that the land was endowed to the temple and their name was entered in the revenue records and therefore they ought to have been heard in the matter cannot be accepted. It will have to be borne in mind that the writ petition was filed 51 years after the order, nearly 50 years after the order was passed by the land tribunal. If the land was endowed to the temple, there must have been some other records to indicate the endowment and also documents to show that this endowed land was put to use by the temple for the use of the temple. So, in fact, as could be seen from the entry in the IL and RR, the entries by themselves state that the lands therein were tenanted, and out of the lease amounts, the religious activity was being performed. This particular statement, by itself indicates that the land was tenanted, and consequently, by virtue of the enactment of amendment to the Land Reforms Act, all the tenanted lands stood vested in the state, free from all encumbrances, and necessarily these tenanted lands would have to be granted to the tenants in occupation. In my view, since there is the records produced by the petitioner do not indicate that there was an endowment in favor of the temple. The petitioner would have no locus standi to challenge an order which was passed way back in the year 1976. Next one. Learned senior counsel, however, seeks to place reliance on the judgment rendered by the apex court, rendered in 1957 Supreme Court 19, to contend that the endowment could be established by which para 6 could be inferred from the revenue records. It must be pointed out in this case that in that case, the Supreme Court was dealing with a case where the properties therein were considered to be subject to a charge in favor of the charities, and the fact that the properties were the subject of the trust was only in denial. In a case where it was not in dispute that the land was subject to a charge of a charitable trust, any observation made therein would have no application to the facts of the present case. What is the other one? Para 16. The senior counsel also placed reliance on the judgment rendered by the Supreme Court in 1916, volume 3, SEC, page 700, to indicate that a dedication of a property for religious or a charitable purpose can, according to Hindu law, be validly made orally and no writing was necessary. So there can be no quarrel with this proposition, but the fact remains that it is not the case of the temple that there was an endowment made to it orally. The only argument being advanced is that the endowment stood established by virtue of an entry in the revenue records. As already noticed above, the revenue records is not based on the basis of a statement given by the landlord, but it is on the basis of information collected by the revenue authorities to make the entry. In that way, the matter, in my view, there is no justification. The judgment would be of no avail to the petitioner. So, as already stated above, it would be improper to interfere with an order which has been passed more than 50 years ago at the instance of the petitioner, who has been unable to establish that there has been an endowment made in its favor. Therefore, the writ petition is dismissed. This number. What are the lands granted after 95 in that land? After 12/10/1995. After 12/10/1995, are there any lands granted? Then how can they not apply this rule to them and only apply this rule? No, madam. You reject claim, you ignore while giving to others. How do you justify this? ಇದು ನೀವು ಅನ್ಯಾಯ ಅಲ್ವಾ? ಇದು ನೀವು ಹಂಗಾರೆ ಅವ್ರ ಗ್ರಾಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತೀರಾ? ಯು ಮೇಕ್ ಎ ಸ್ಟೇಟ್ಮೆಂಟ್ ದಟ್ ವಿಲ್ ಕ್ಯಾನ್ಸಲ್ ಆಲ್ ದಿ ಗ್ರಾಂಟ್ಸ್ ಮೇಡ್. Then I'll dismiss the writ petition. Why do you do this selectively? I'll have it tomorrow, ask him to fill an affidavit. Why do you want to take it upon yourself? You have to tomorrow. Want to continue? Let us see how best I can try to. Wait till Thursday. Let us see what they'll do. I don't want to deprive you of the property. At the same time, I don't want him to be targeted like this. After vacation. What is the stay granted? WP 35378. In 35378. WP 35378 should continue that. Seventy? 35378. 35378. What is the interim? What is the stay of? What is the interim order that you obtained in 35378? Conversion order. Why are there two writ petitions then? Why are there two writ petitions? Page 24. Page 24 and WP 35378. Same order is challenging the other writ petition also. Second body. Ade Prakash. Adil, what is the challenge in this case? On what ground are you challenging order of conversion?
land was purchased by respondent's grandfather in the year 1936. Later on, my lord, which is continued, revenue records are continued. Later on, he will accept what he wants to say. On the level of obtained a CC, thereafter e-Khata was made, my lord. Now they are.
Day after tomorrow.
No document is provided member to the government from 1936 by virtue of this state and subsequent documents. They are
88. Day after tomorrow.
Names of the incidents have not been given, so I am unable to. Again, there are some changes.
Where's Pavan? Pavan Kumar ಇಲ್ಲಿ. Where is Pavan Kumar? BBMP ಗೆ. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ. ಹಾ ಬರಲಿ ಇವತ್ತು ಬೇಡ ಅಂತ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. 20 day after tomorrow. Day after tomorrow. ಕೊಡಿ. ಏನ್ ಮೇಡಮ್?
They saying that without there being any revenue documents, I can't get any compensation. That's why we have given representation to the revenue department to consider my name in the revenue records to get the compensation from Metro. Actually, is the grant certificate, and my name is reflected in Sakoli, Uttarana, City, ಇದೆಲ್ಲ reflect ಆಗಿದೆ, payment ಮಾಡಿದ್ದೀವಿ.
Consider ಮಾಡಿ. The player in this petition is to direct the respondents to register the kata in favor of the petitioner. So the petitioner contends that she had given a representation on 11/8/2020 by Annex H, whereby she had informed the authorities an extent of 2 acres had been granted to her in the year 1972 by LND SR 1606/7273 and dated 20/11/1972, and therefore her name was required to be entered in the revenue records. Since the petitioner contends that the lands were granted to her and her name is required to be entered in the revenue records, and she has also produced documents to show that a Sagodi chit had been issued in her favor, it would be appropriate to direct the fourth respondent to consider the request of the petitioner in accordance with law and pass approved orders within a period of 2 months in the date of receipt of a copy of this order. ಯಾರು ನೀವು ಯಾರಿಗೆ? Do you have any objections? ಹೇಳಿ, ಜೋರಾಗಿ ಹೇಳಿ. After vacation. 21 writ petition ಅವಸರ ಏನಾಗುತ್ತೆ ಬಿಡಿ. After vacation. What documents? What do you want now? After vacation.
Number 3, I made a recommendation to the officer to try to transfer the content to the commissioner. With recommendation of number 3,
What are you challenging? Annexure R. Next, SL ಏನು ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು?
ಎರಡು ಅಪ್ಲಿಕೇಶನ್ ತಗೊಂಡು ಕಳಿಸಿದ ಆಕ್ಷನ್ ಕೇವಲ
Where is the order of the AC? Madam, AC order ಇದ್ದು how can you not do this? ಇಲ್ಲ, I'll ask him to consider this annexural and then redecide them. The ಇಲ್ಲ ಕಣ್ರಿ, ಈ ಅನೆಕ್ಸರ್ 6S ಅಲ್ಲಿ ಈ ಆರ್ಡರ್ನ ಏನು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. So I will set aside this order and direct him to consider the annexure L order. The petitioner is aggrieved by an order passed in a proceeding initiated for mutating the names of the petitioner. By the impugned orders, the Tahsildar has directed maintenance of status quo, essentially on the ground that there was a difference in the names proposed in the checklist and that of the Khatedar. It is a case of the petitioner that an appeal had been preferred by the Tahsildar before the Assistant Commissioner under section 136 of clause 2 of the Land Revenue Act, and in these proceedings an order was passed in the following terms by the annexure L marked portion, and it is contended that in the light of this order the Tahsildar was bound to enter the name of Nanjappa, but the Tahsildar has acted contrary to the order of the Assistant Commissioner. The perusal of the orders produced in annexure R and S indicates that the order passed by the Assistant Commissioner has not even been noticed by the Tahsildar, let alone be considered by him. In that way of the matter, annexure R and S will have to be quashed. The order dated 21/1/21 and 5/2/2021 in RRT number 233 and RRT number 234/2020 will have to be quashed, and the Tahsildar will have to be directed to reconsider the matter, keeping in mind the order passed by the Assistant Commissioner in RRT CR 324/1819 on 27/1/2020, annexure L. So this exercise will be carried out undertaken by the Tahsildar within a period of 3 months. Let us receive a copy of this order. Goes along with vacation. Ready na? After vacation. ಹೇಳ್ರಿ ಬರ್ಲಿ ಬಿಡಿ, 2 ಗಂಟೆಗೆ ಬರ್ಲಿ ಬಿಡಿ. ನೋಡ್ ನಮ್ದು ಅದು ಮಜಾ ಮಾಡೋಣ ಅದ್ರ ಗ್ರೌಂಡ್ ಮೇಲೆ. Release after vacation. ನಿಮ್ಮ ಹೆಸರು? Stated that R. Venkatesh has entered appearance for R5 and R11. Always to print his name and release after vacation. 22ನೇ ವರ್ಷದ ನೀವು ಸ್ಟೇ ಕೊಡ್ಲಾ? ಯಾರ್ಲಿ 22 ವರ್ಷದಿಂದ 22ನೇ ಸ್ಟೇ ಕೊಡಕ್ ಬರುತ್ತಾ ಇವಾಗ 3 ವರ್ಷ ಆದ್ಮೇಲೆ? I'll have this day after tomorrow. Find out if you're taking compensation. If you're trying to withdraw compensation, I'll directly to be kept in deposit. Are you ready to argue now? Day after tomorrow. Who's opposing you?
Shivrama. That including application is filed, my lord. That may be allowed at least.
ಯಾರು ಹಾಕಿದ್ರು? ನೀವು ಹಾಕಿರೋದಾ?
Sorry.
ನೀವು ಹಾಕಿರೋದಾ?
On 3rd April, I have filed. In fact,
Whom do you want to implicate?
That Swamiji, my lord, who was the assistant commissioner, additional DC, who sanctioned the land.
Notice ಹೋಗಿದ್ಯಾ?
Sorry.
Notice ಹೋಗಿದ್ಯಾ? Issue notice on IA2/25.
No, I'm ready in the main matter also. But short date.
He's not here. What do I do?
Short date. Interim order.
ಇದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡಿ ಕಂಟಿನ್ಯೂ.
For the petitioner, Lord. Lords, I heard it on the last occasion also. Lords, I file a revision application, Lords, before the DC, my Lords, on the challenging revenue entry, my Lords, that my son made on the basis of unregistered partition deed, my Lords. The deputy commissioner, my Lord, says that I have to file a suit, my Lord, before the civil court. I have already filed a suit where there is a compromise decree, my Lord, between me, the petitioner, and the petitioner's son. My Lord, may see page number 97, my Lord, the compromise decree.
You and the petitioner's son.
I and the petition, I and the son, my Lord. I am the petitioner is the mother. Respondent is the son of the petitioner. My Lord, may see page number 99, my Lord, the compromise decree. 2010, my Lord, so land is granted by municipality, my Lord.
Challenging annexure A.
Annexure A. My Lord, may see annexure A, page number 18, my Lords. Page number 20, the order, my Lords, Adesha, and above that, my Lords. ಆದುದರಿಂದ ಈ ಪ್ರಕರಣದ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ದಾವಾ ಜಮೀನಿನಲ್ಲಿ ಹಕ್ಕು ಹೊಂದಿರುವ ಬಗ್ಗೆ ಮತ್ತು ನೋಂದಾಯಿತ ದಾಖಲಾತಿಗಳ ನೈಜತೆ ಬಗ್ಗೆ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಶ್ನಿಸಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳಬಹುದಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಪ್ರಕರಣದಲ್ಲಿ 1ನೇ ಪ್ರತಿವಾದಿಗಳು ಪ್ರಶ್ನಿತ ಆದೇಶದಲ್ಲಿ ಹಸ್ತಕ್ಷೇಪ ಮಾಡುವ ಅವಶ್ಯಕತೆ ಕಂಡುಬಾರದೆಂದ ಈ ಕೆಳಗಿನಿಂದ ಆದೇಶಿಸಲಾಗಿದೆ.
It was done on the basis of registered partition deed.
Unregistered partition deed. The revenue entry, my Lords, was made on the unregistered partition deed at page number 101.
It was
Annexure
made on-
J.
Please. Lords, based on the partition deed, I gave an application, my Lords, it was mutated, my Lords. Then, my Lords, again, they filed a civil suit, my Lords, which came to be decreed, my Lords. Page number 98, my Lords, if I may read, my Lords.
Compromise decree, my Lords, page number 99.
98, my Lords, paragraph number 4.
Yes.
In pursuance of the settlement arrived at, the plaintiff hereby withdraws all the allegations and claims made by her against the defendant and further admits the right, title, interest and possession of the defendant over the suit scheduled properties.
Lords, may see paragraph
That's
number 6,
six,
last
my
line
lords.
also.
Paragraph number 6, my lords. In respect of two shops, my lords, they agreed that amount of rupees 8,000 will be given to her till her lifetime, my lords. She doesn't have any kind of
Against you then.
Lords, the paragraph number 6, the last lines, ma'am. After the death of the plaintiff, the defendant is entitled for all the benefits as absolute owner thereof.
No, then what is the meaning of the first one? And further admits the right, title, interest and possession of the defendant over the social properties.
Lords, that is after the my lord's death of the petitioner. Lords, the petitioner, my lords, even my lords, assuming for a
first there
fact,
is a partition deed, my lords. On that
even assuming
partition
for a
deed,
fact, lords, the annexure says that the respondent, my lords, have went.
You have to challenge this compromise as being fraudulent or for whatever reason.
Please.
It is not clear as to whether your name should continue as the owner till your death. You are ready to collect 8,000 rupees a month as rent and give up all the claims. Now you are coming back and saying, no, my name should be in the records.
Lords, the unregistered partition deed, my lords.
But what about the decree, compromise decree thereafter between the two of you?
Please.
Then. ಕೊಡ್ತಿದಾರ ನಿಮ್ಗೆ?
Please, my lord.
ಅವರೇ collect ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ.
That
is receiving by way of hand.
ಜಗಳೇನೋ ಬೇರೆ ಇದೆ, ಇರ್ಲಿ ಬಿಡಿ, ಸುಮ್ಮನೆ ಯಾಕೆ?
My lords, may have it day after tomorrow.
ಏನಕ್ಕೆ?
Lord, senior ಬರ್ತಾರೆ.
ಏನ್ ಬೆನಿಫಿಟ್ ಆಗುತ್ತೆ ಹೇಳಿ ನಮ್ಮ ಮಾಡಿ?
Lord,
can I pass a different order on ನಿಮ್ಮ ನೋಟಿಸ್ ಇಷ್ಟು ಕೇಳ್ತೆ, ನಿಮ್ಮ ಸೀನಿಯರ್ ಬಂದ್ರೆ ಇಷ್ಟು ಕೇಳಲ್ಲ.
Lords, may have it tomorrow. Lords, may have it tomorrow. Lords, my request. Lords, day after tomorrow.
Day after tomorrow. Remind me day
after vacations, my lords.
Missed after vacation.
Lords, day after tomorrow.
I sought declaration to the effect that the application which I have made for conversion, my lord, deemed to have been granted by virtue of section subclass 5 of section 95.
Endorsement ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇಲ್ಲ, ಕೊಟ್ಟಿಲ್ಲ ಅವರು. 28 the application was made on 14/9/2023. Till now there is no endorsement issued. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ, I will make this statement also. One person who has filed the suit for partition has objected to conversion. That suit came to be dismissed. With these documents, I will go before the deputy commissioner. Let them issue the conversion order. ಅಷ್ಟೇ.
ಏನ್ ಮಾಡ್ಲಿ? ಏನಂತ?
Let them take.
When did you make the application?
14/9/23, my lord, annexure K at page 90. Online application. 89 and 90. Page number 89, annexure K and K1.
Seeking for a declaration that there is a grant of a deemed permission under section 95(5) in respect of the application that the petitioner had filed on 14/9/2023, seeking for permission of the deputy commissioner to use his land bearing old survey number 117/2, new survey number 117/12, measuring 1 acre 1.5 guntas in Vadrapalya, Uramavu, Agrara Dakla, Kerpam Hogli. It is a case of the petitioner that on 14/9/2023, he had given an application, he had submitted an application online seeking for permission of the deputy commissioner as contemplated under section 95 of the Land Revenue Act for using the agricultural land for non-agricultural purposes. It is contended that though more than 4 months have elapsed, no order has been passed and the deeming provision would come into operation. The Council appearing for the petitioner also submits that the Deputy Commissioner did not pass any order, probably because a suit for partition was pending and the plaintiff therein had raised objections. Learned counsel points out that the said suit filed by the plaintiff therein, that is OS 5775 by 2006, has in fact been dismissed on 15th of January 2025. And therefore, even this objection would be of no relevance. In the light of the above, I am regard to the fact that the Deputy Commissioner has not exercised his power to refuse permission within a period of 4 months, the Deputy Commissioner is directed to accord permission under section 95(5) of the Land Revenue Act as sought for by the petitioner. WP is accordingly.
The 79 AB Millet, within 2 days, the impugned order is passed, Millet. No opportunity.
How much is the order?
Millet 2016 Millet. And annexure E page, Millet. 29 Millet.
Hello.
Great.
Sir, 4-week pleadings already closed for issued summons to respondents.
What are you checking?
For objection or any.
What is annexure H?
Next order.
What is your grievance?
ಭಾಸ್ಕರ್ ಸರ್ ಅವ್ರಿಗೆ ಅವ್ರು ಏನು ರೆಸ್ಪಾನ್ಸ್ ಮಾಡಿಲ್ಲ ರಿಟರ್ನ್ ಅಂತ ಹೇಳಿ.
ಯಾರು ರೆಸ್ಪಾನ್ಸ್ ಮಾಡಿಲ್ಲ?
ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಅವರು ಸಮನ್ಸ್ ಕೊಟ್ರಿ ಸರ್. ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ಗೆ, ಬಟ್ ಅವ್ರು ಏನು ಆನ್ಸರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ.
No, you don't want to file objections. Appears to be a rejection of his form. Objections occur, at least he will know. DGA 6 time to file these objections. Really strong on date code. 4 July.
Sorry, 107 that is posted to today. Sorry, sent up with the
Notice order ಮಾಡಿದೆ.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅವ್ರಿಗೆ ಆಲ್ರೆಡಿ.
ಇಲ್ಲ ಇಂಪ್ಲೀಡಿಂಗ್ ಮೇಲೆ ನೋಟಿಸ್ ಮಾಡಿದ್ದೀನಿ. ಅವ್ರು ಹಾಕಿದಂತ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಇಂಪ್ಲೀಡಿಂಗ್.
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್.
ಅದ್ರ ಮೇಲೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿ.
The copy was not served on us.
ನಾನು ಹಾಕಿದ ಅಪ್ಲಿಕೇಶನ್ ಅಂದ್ರೆ ನಾನು ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿ.
Please. The date is given. Please.
Milord, appeal for the petitioners. Basically, under 79A and B, Milord, the order has been passed after 18 years from the date of the, Milord, what have challenged? Milord, are 2 orders. One is a judgment passed by the tribunal. Milord, we are third parties. Milord, the first, Milord, your lordship may kindly see.
What are you challenging? Annexure AA.
Annexure AA at page 234 and 244. There is an order passed by the tribunal, my lord. But there was delay. There was delay in approaching because we are third parties. We were unaware of this order passed, impugned order passed by the assistant commissioner has dismissed my application.
In 79A B.
79A.
118 ಅಂತ ಇದೆ.
Annexure T. Annexure T at page number 202, my lord. typed copy.
Next area is salient copy.
Annexure T, my lord, T. 202.
79 AB.
ಇಲ್ಲ ನನ್ನ ಹತ್ರ ಫೈಲ್ ಕೊಟ್ಟಿಲ್ಲ ಮೇಡಮ್ ಸರ್ ಒಂದು ನಿಮಿಷ ಕೊಡಿ ಮೆಲೋಡ್
Notice ಇಲ್ಲ ಅವರಿಗೆ. What the assistant commissioner says is that the notice has been affixed on the site, whereas there is a different procedure prescribed under the land reforms.
WP allowed.
Grateful.
Late 50 Mellon. Respondent number 629 Mellon. Will filed objection Mellon. And no Sokla filed on 15/4 Mellon.
ನಿಮ್ಮ ಹೆಸರು
ಅರವಿಂದ್ ನಿಮ್ನೆಗ್ಲು.
ಹಾಕಿ ಹೆಸರು ಇದೆಯಲ್ಲ?
Objection file ಮಾಡ್ತೀವಿ.
ಮಾಡ್ತೀರಾ?
2 weeks time.
Lord, they have already, this council was already on the on record advocate in earlier round of litigation.
He said he wants to file objection. Not realist application.
And particular date may be not the.
I'm appealing for respondent number 10, 12 and 26.
But
I may have to file objections. It's almost ready here.
realist.
But can I make one request is to, not because due to paucity of time, not the court also said not that interim order with regard to not alienation. Now not Mudam not has passed an order. On the basis of the order passed by this honorable court not filed a memo not on 17th. Yeah, Hilwa. This pass on not a copy.
Development and 2 days
But the interim order was granted on 27/1/2025.
Interim order quoted, what do you want now?
But now, Lord, Mudam, Lord, on the basis of this interim order says, don't do anything in the property. Lord, that is not the order.
Who appeals of Muda?
There, Muda is not even a party, Lord. But not these respondents not go to Muda on basis of this order.
Without them being a party, what is interim order against them?
I'm only saying, Lord, the respondents not should not precipitate on the basis of this interim order, Lord, because they go with this interim order.
You're protected by an interim order. If you
Yes.
want some prayer, I can set, implement them as a party.
Very well.
Realist.
The interim order may be extended. Great.
petition ಆದ್ಮೇಲೆ ಇದ್ರಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿ
Weeks time to complete with the subjections.
Appear for petitioner in this case, my lords. We have filed an writ in the nature of mandamus, my lords, directing the respondents 4 and 5 to conduct spot inspection, survey and effect 4D, my lords. The online application has been made, your lordship. 29/11/2023, which is the annexure G, your lordship.
When?
29/12.
Annexure?
Annexure G, my lords. A representation is given, my lords.
ಇಲ್ಲ ಉಲ್ಲೇಖ ಇದೆ ನೋಡಿ ಅರ್ಜಿ ನಂಬರ್ ಸೌಂಡ್ಸ್. Thursday.
Much obliged.
I want to 2 weeks time to file the objection.
No, on submission, my lord, there is urgency in matter, waiting from long time.
Already-
Lordship directed me to take notice, then ultimately I had to serve the notice.
RFA already they have
Interim
taken stay.
because mutation was affected during the operation of the stay in the appeal, my lord.
Declaration
Even despite it was brought to the, my lord, the mutation was affected. In fact, the
What are you challenging?
respond 4 to 6, my lord, had filed the suit.
What are you challenging now? Not challenge ಮಾಡ್ತಿದ್ದೀರಾ?
Mutating the property in the name of the response 4 to 6 by the Tahsildar.
Next year.
Annexure J and K. In fact, stay was brought to the notice of the authority. Then I preferred appeal, my lord, it was rejected.
ಏನು?
Annexure J and K.
ನಿಮ್ಮ ಹೆಸರು, ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಹೆಸರು.
Earlier, it was transferred to Malaya, the father of the respondent 4 to 6, my lord. Then 4 to 6.
Annexure J.
Annexure K.
ಮಲೈನ ಹೆಸರು ಬಂತು. ಆಮೇಲೆ
ಅಲ್ಲಿಂದ ಅವ್ರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರು when the stay was operating. From 1980, my lord, the property was in the name of my predecessor.
ಇವಾಗ ಚೇಂಜ್ ಆಗೋಗಿದೆ ಅಲ್ವಾ? ಚೇಂಜ್ ಆಗೋಗಿದೆ ಇವಾಗ.
ಅಲ್ಲ ಚೇಂಜ್ ಸ್ಟೇ ಇರುವಾಗ ಮಾಡಿದ.
ಆಯ್ತು, ಇವಾಗ ಸ್ಟೇ ಆಗೋಗಿದೆಯಲ್ಲ.
ಯಾವುದು?
ಚೇಂಜ್ ಆಗೋಗಿದೆಯಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು ನೀವು?
ಅಲ್ಲ ಇಂಟ್ರಿ ಬಿಕಾಸ್ when the that was brought to.
ಅಲ್ಲ ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಡಕ್ಕಾಗುತ್ತೆ?
ಅಲ್ಲ ನಾನ್ ಹೇಳ್ತಾ ಇರೋದು ಏನು ಅಂದ್ರೆ when she had filed the suit before the trial court, my lord, for declaration that my gift deed is null and void. The court declared the suit. I preferred appeal. The judgment and decree was stayed on 13th April. Subsequently, despite the fact it was brought to the notice, Tahsildar changed the mutated the property.
What stage is appeal pending? Appeal ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಅಲ್ಲ appeal dismiss ಆಯ್ತು.
RFA is pending.
No, appeal pending. Appeal is pending.
ಇದನ್ನು RFA ಜೊತೆ ಹಾಕ್ಬಿಡ್ತೀನಿ.
ಅಲ್ಲ admit act stay ಆಗಿದೆ. So that's what it was brought to the your lordship notice.
There is one decree.
When lordship had questioned me when it was when it on stage of preliminary that when the stay in operation, how could it be mutated the property?
When you see my annexure N, DC order.
DC order says
the endorsement.
He will not interfere.
Challenge,
he will not interfere.
Because of the RFA pendency.
He will say RFA is pending.
He issued notice endorsement.
The stay is operation.
Before
it was starting in my name. 23-24, it was in my name. Without my notice, it has the property is mutated.
He has to succeed in RFA, then only.
Basis of the decree, my lord, they applied for the mutated the property.
I will say that this will be subject to the result of the RFA.
Please, my lord.
This entry that is
my lord, what happens is they will interfere with my possession. Taking the
RFA ಅದ್ ಕೇಳಿದ್ರೆ ನನಗೆ ಅಲ್ಲಿ ಕಳಿಸ್ತೀನಿ ಜೊತೆಲಿ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ.
Till then it will interim stay may be granted.
Interim stay ಏನ್ ಕೊಟ್ಟಾಗ ಆಗ್ಲೇ ಚೇಂಜ್ ಆಗೋಗಿದೆಯಲ್ಲ.
ಅಲ್ಲ ಅದು ಕನೆಕ್ಟ್ ಮಾಡುವಾಗ
ನೀವು ಹೇಳೋದು ನೋಡಿದ್ರೆ ಅದನ್ನ ನಾನು ರಿವರ್ಸ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಎಂಟ್ರಿ ಮಾಡೋ ಮುಖಾಂತರ. ಅದ್ ಮಾಡಕ್ ಆಗುತ್ತದೆ ಇಲ್ಲ. Along with the RFA, make an application injunction or whatever you want there.
It is an illegal order.
It is already done now. There's nothing.
When it was, despite your lordships, the order was brought to the notice.
No, now that you have told me that RFA is pending.
That has to be.
Interfere at this stage.
So let it be given opportunity to me.
RFA number ಕೊಡಿ.
ಅಲ್ಲ authority opportunity ಕೊಟ್ಬಿಟ್ಟು decide ಮಾಡಲಿ.
RFA ಕೊಡಿ.
They will interfere now, my lord, without.
Stay is there. RFA 767 of 2023. 767 of 23.
No, they will. One minute, my lord. Lordship, kindly.
Please.
ಅಲ್ಲ mutation effect ಮಾಡಿರೋದು ನನ್ನ ತೊಂದರೆ
ಆಗೋಗಿದೆ ಇವಾಗ. I can't reverse it by way of an interim order.
That has to be quashed, my lord.
ಇವಾಗ RFA ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಸ್ಟೇ ಇರುವಾಗ ಮುಟೇಟ್ ಮಾಡಿದ್ದಾರೆ.
DC ಹತ್ರ DC
ignoring the
ಕೈಲೋರೆ ನಾನು DC order endorsement quash ಮಾಡಿದ್ರು. I will ask him to reconsider only. I can't ask him to restore the entry in your favor.
No, mutation to.
He has only refused to entertain.
Illegal order when the order is enforced, my lord.
RFA ಜೊತೆ ಬರುತ್ತೆ ನೋಡಿ.
Application for grant of land under the military quota is pending from 1985. Prior to that, the very same land was. It is in our possession from 57 under the lease. Father of the current petitioner, Annexure B.
ಏನ್ ಮಾಡ್ತೀರಾ?
1985 application, no, my lord, I thought for.
The proceedings have gone on till 2020, my lords.
Now, what is this? I don't understand. What is the, an application received?
Yes, my lords. At the application, it said 17. I was serving in the military, my lords. The petitioner was a soldier then. Through the channel, my lords, he has sent it. The application is, his father was granted 5 acre 94 cents of land, my lords, in Kandavara village for cashew cultivation in 1957. That lease was in currency till 87. Since I was a soldier, my lords, an application was made through me within the family for grant of the said land.
The petitioner had made an application requesting for reallotment. Allotment of cashew nut.
The land which is in our cultivation. In ಬೇರೆ ಇನ್ಯಾವುದು ಕೊಡಕ್ಕಾಗಲ್ಲ.
For regranting the land which had been leased to his father in cell number 228/1, measuring 5 acres 94 guntas for cashew nut cultivation. It is the case of the petitioner that his father, who was serving in the army, had been leased with the land for a period of 30 years. And the petitioner is also working in the army and is likely to be discharged on medical grounds shortly, and therefore he is basically seeking for continuance of the lease that had been granted to his father. In my view, since the petitioner is contending that he is likely to be discharged from the military on medical grounds and is requesting that the land leased to his father be granted to him by way of a reallotment, it would be appropriate to direct the deputy commissioner, respondent,
Second respondent,
to consider the request of the petitioner in accordance with law within a period of 2 months from the date of receipt of copy of this order. Three months, huh?
but the deputy commissioner has already recommended Annexure D. It's only a formality that it has to be approved. It got delayed because there was no objection from my family.
Appear of petitioner, kindly have to, tomorrow, 24th. Kindly have to.
In matter.
There is a rejection of unauthorized application made by the deputy commissioner and.
After vacation.
Submission is earlier in contempt petition, government submitted that survey and pod is already done, but actually and physically it is not done. The wife of the grantee again requested the government to make a survey and pod. The same, seeking the same.
Day after tomorrow ಕೇಳ್ತಾರೆ ಅಷ್ಟೇ.
ಆಗ್ಬೋದು. ಅದೇ ಎರಡು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Please.
But sale deed was executed. Sorry, my lord. Partition deed was executed as per Annexure B on 29/3/23. My lord, on the basis of that partition deed, to make an entry, I made.
The prayer listed petition is to issue a direction to the authorities to consider the representation dated 21/20/25 and 7/3/2025, whereby the petitioner is requesting that his name be registered in the revenue records as a Khatadar. Since it is a registered document in his favor, then suit eno?
Suit is for partition, declaration on partition.
ಏನಾಗಿದೆ ಅದು?
ಅದರಲ್ಲಿ not only there is an interim order.
Final order in the
ಇಲ್ಲ.
In my view, since the petitioner is requesting that his name be entered revenue records as per registered document, it will be appropriate to direct the respondent. Respondent number 3 to consider the request of the petitioner and pass an appropriate order in accordance with law within a period of 3 months from the date of receipt of copy.
Seeking for direction to the Tahsildar to implement Assistant Commissioner's order. 2023 Assistant Commissioner has passed the order.
Notification.
Therefore,
application for conversion of 1 gunta of land for residential purpose. Without any reasons, applications are denied. Matter was listed on 8th and time was granted to my learned friend. No reasons, A, B, C, D, kindly.
Let him reconsider it. The petitioner is aggrieved by the rejection of the petitioner's request for permitting him to use the agricultural land measuring 4/13, measuring 1 gunta for residential purposes.
There are two applications. Two applications.
4/14 and 4/13.
Yes.
ಎರಡು ಸೇರಿ ಒಂದೇ ಒಂದು ಗುಂಟೆನಾ ಇಲ್ಲ? Both together measuring 1 gunta.
Pardon?
ಎರಡು ಸೇರಿ ಎಷ್ಟು measurement?
1 gunta each.
1 gunta each. The Deputy Commissioner in the impugned order merely states that by virtue, because of a report of the Tahsildar and the Deputy Chief Commissioner, he was rejecting the application. So, in other words, the Deputy Commissioner has not assigned any reasons for refusal to accord permission to use 1 gunta of land in the aforementioned survey numbers for residential purposes. In my view, therefore, annexure A and B cannot be sustained and they are accordingly quashed. The DC is directed to consider the application of the petitioner and pass an appropriate reasoned order on the application within a period of 2 months from the date of receipt of a copy of this.
1 month may kindly.
1 month.
My lords, Selam 38 has been passed over.
Pathway.
One matter, the road, existence of road. I could not be here well in time.
23rd one.
May I just file written submissions so that. I'll file.
ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಕೊಡಿ ಸರ್ 23rd ನಾಡಿದ್ದೆ ಅಲ್ವಾ ಅವತ್ತೇ ಕೊಡಿ
ಓದ್ತಾರೆ
ಅವತ್ತೇ ಕೊಡಿ ಓದಕ್ಕೆಲ್ಲ ಟೈಮ್ ಇಲ್ಲ ಬಿಡಿ ಸರ್
Then court said that we can pass over. And I asked again.
Tell me.
And I asked the second time.
ಮಾಡಿದ್ರು 10 minutes ಅಲ್ಲಿ ಹೌದು 10 minutes ಅಲ್ಲಿ ಬರ್ತೀವಿ ಪಾಸ್ ಓವರ್ ಅಂತಂದು ಅಂತ ಹೇಳ್ಬಿಟ್ರ ಸೊ ಪ್ರಾಬಲಿ she might not have heard it. He has also not heard it.
ನಾನು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಬೇಕು ಅಂತ ಸಾಹೇಬ್ರು ಡೇ ಆಫ್ ಕೇಳಿಸ್ಕೊಂಡಿದ್ದೆ. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಇದು ಏನು ಬರಲೇ ಇಲ್ಲ ನೀವು ಆನ್ ರೆಕಾರ್ಡ್ ಇಲ್ವಲ್ಲ.
ಇಲ್ಲ ಇದು